be it live in the Zoom meeting, or be it live on the stream, or be it watching the video afterwards recorded. The session of NFDI InfraTalks introduces topics from the various so-called NFDI consortia. And as you might know, we have plenty of them. As of now, we have 19 consortia spanning the range into different various scientific disciplines. And one of the topics that is common to many of these consortia and to many research disciplines is the challenge of legal aspects. And it's a great pleasure to have here today an expert for legal challenges, legal questions. I'm very happy to have you here, Fruzsina Molnár-Gábor. She happens to be a young research lead at the Heidelberg Academy of Sciences. And to make a long story short, she has had already a very successful scientific career in the sciences. She specializes on various forms of law, and I'm not a particular expert in law, so please forgive me as I'm not really able to distinguish the subtle notions of the different laws that you're looking for. However, she likes to combine these legal aspects with challenges from other areas. And these areas are manifold, be it machine learning, or be it, as of today, the question about the processing of genomic data, which probably also involves maybe machine learning. So she really brings together different aspects from various disciplines. And it is really noteworthy that she has received a number of awards for her scientific work. And I was pleased to see that you also received the Heinz Meyer-Leibniz Award from the DFG in 2020, which is a prestigious award for young researchers. The floor is yours, Fruzsina, please.
Yes, thank you very much for this very kind introduction, and thank you for the invitation. I'm very pleased to be here and to give a talk within the NFDI InfraTalks. And I'm very pleased to see many, recognizable names who I all know from the different NFDI consortia, particularly from my own one, the German Human Genome Archive, but also, of course, all the others, as this is all about the networking and federating all the NFDI consortia also towards our main core and joint aim. My topic today is actually the one that you have just described exactly, is legal challenges around genomic data sharing. I will now try to share my slides, and I hope that this will also work. So you should be able to see my slides now, and you should be able to see it in a presentation mode. Could you please confirm?
Works fine.
Okay, thank you very much. Yes, thanks again for the very kind introduction. I really do try to merge different perspectives of law on emerging technologies that are related to health and medicine, and also scientific research. So the framing was perfect. And as regards NFDI, I am involved in the German Human Genome Archive consortium, which is, of course, the main point why this talk is focusing on genomic data and the legal challenges around that. But there is another, maybe not really secondary point that has been occupying our thoughts from those who are acquainted with international and national data sharing. Is really the long-standing and now many decades-long development of genomics in research and also evolving in medicine, where the costs and analysis time of genomic data collection have been reduced severely, which means that there are huge amounts of genomic data that are ready to be analyzed and used for scientific research and medical purposes. And we all know that combining this genomic data with clinical data and also lifestyle information, we are now ready to learn and have learned a lot about different diseases. And through these huge data collections, there is a possibility to also translate research results into clinical settings and to improve medicine. And I think this broader framing is quite important for this talk. And when we think about the legal challenges around sharing this kind of data, so the translational scope, and I will be coming back to this scope also on other slides. If we think further about sharing this data, and if we think about the different processes that are related to analyzing this data, I have highlighted just a few very basic notions that I have learned from the scientists I'm working with in an interdisciplinary manner, and who have taught me why this genomic data sharing, whichever level we are thinking of, is really important. I have already mentioned some of them, but of course you will recognize as scientists many other aims about this data sharing and drawing together data and also making it accessible for various purposes for primary and also for secondary users, which you could basically summarize with our main term and leading principle within the NFDI: fair data sharing, findable, accessible, interoperable, and reusable towards genomic medicine and towards the translational perspective. I would like to have a short talk in my presentation about the German Human Genome Archive within the NFDI, so you understand the second framing I'm having for this talk. The core mission of this consortium is to establish a national infrastructure for the sharing of this very data, for human omics data, which is not just genome, but transcriptome, proteome, and other omics data. And the way we would like to do is the long-term federated connection of different centers in Germany who are already involved into this data management and data collection and data processing, to then, through the bundling of this federated infrastructure within Germany, provide controlled access and possibilities and community-centered data sharing platform where researchers can come and use this data for their scientific purposes. And in order to do that, there is quite a large amount of work done within the consortium to frame this in an ethico, legally sound way, to provide a data governance framework from the normative perspective for this data sharing that respects ethical principles and obligations, but also compliance with the law, which is basically the GDPR, the EU General Data Protection Regulation, which is an EU regulation directly binding for member states, but also leaving room for their own rules, and which has been also occupying our thoughts in the last 5 years in the meantime, when we got the first draft. So this is actually the main part of the work that has to be done to ground this whole infrastructure in a compliant and sound way. And this is the part of the work, this whole governance framework in a very broad sense, I'm involved in, of course, with other colleagues who I will come back to in a second. Why is this really a very crucial contribution to FAIR? Through making all these data accessible, really through a distributed analytics platform, I think that an enhanced possibility to participate for scientific researchers is going to emerge, which I think is in this distributed and participatory sense also on the scientific research side, very important. And the second relevance is also that we are very much aiming at using this infrastructure once it's built and while it's built to connect it to European and internationally significant other infrastructures. And while there are quite a lot of data infrastructures, our main focus internationally lies with the European Genome Archive, which aims by creating national nodes to connect or national data infrastructures, including for omics data, and to make this data shareable. And our aim is to become such a node for Germany within this infrastructure. So how does it look like exactly as of now? We are involving leading institutions in genomic medicine, which you can see on this land card. And those are the major omics data producers in Germany, including the DFG sequencing centers and also the centers connected to the DEMBI cloud infrastructure. There are some other collaborations, but one main important is that actually as partner in a broader sense are all the communities that are envisaged through this whole infrastructure, which is those that are devoted to human sequencing data in a research context, with two leading use cases, rare diseases and cancer, but also then moving towards other use cases and contexts of human sequencing data usage for research beyond genomic data, and also by creating synergies between these different communities who could be possible users and benefits of this infrastructure. We are part of the national research data infrastructure, which makes us very proud and gives further possibility to connect to other also health-related infrastructures. You can see the main cornerstones of our consortium on the slide, as related to the funding, as related to the board of directors, the leading persons, and to mention that we have 46 participants, PIs from 21 institutions. So this is really bringing together many scientists in Germany to build this infrastructure, which is rather important. And our main aim is also to remain and even become more inclusive, as we are now. I have mentioned the term translation, and I think this really needs to be emphasized further as a binding concept or a binding principle between research and clinical care. We are often talking about scientific research in the medical context as a secondary use of clinical omics data, which is correct also from a data protection legal perspective. However, this whole biological discovery and replication and the possibility to validate results through these research endeavors is quite important. So it's probably better described with the notion further processing of this data in order to probably a little bit solve this hierarchical relationship between different usages. I think that translation, and that's becoming more than obvious through the research insights, is really delivering value also to genomic medicine and healthcare. And it's also translational in a way that it binds different communities together, computational biologists, molecular genetics, clinical scientists, and also physicians, and not to forget the patients who are the main focus and main actors in the whole story. So this translational perspective, I think, has different dimensions, which we need to keep in mind when we think about all these processes and building infrastructures physically around these concepts and terms. Just to emphasize why probably we have picked the both two leading use cases to start off with when developing this infrastructure. I'd like to emphasize cancer and rare diseases again, which will definitely not be exclusive, but other communities are also going to be involved. But as you can see, based on the numbers on the slide, it's quite important to emphasize that cancer is still responsible for 20% of deaths in Germany, and that omics and omics research can reveal disease mechanism and stratify patients in different groups who can be addressed specifically with particular therapies. So it's very important. And the strong movement behind this data sharing is about the validation, the replication, the proof of all these results, and also learning from the data in order to be providing precision medicine. And the same goes for rare diseases. Even more, of course, data sharing is relevant in order to find the real cause, not just correlative, but causal mutations and changes in the genome are responsible for many diseases. So this is even more prominent for data sharing, I guess, as a case, if one could say that. But of course, brings along, as I will mention, much more insensitive data protection issues, as all diseases and factors identified might be really identifying in particular for certain groups or persons. But that was just to emphasize again the leading use cases and how we are starting off related to the content of the data that we will be expecting. I wanted to show you a slide about this international perspective of GHGA, which is quite important in order to connect to international initiatives. It also has to do something with the legal framework we are moving within. Our main scope is the GDPR, as I have mentioned, which is directly binding, but it not fully harmonizes the laws in different member states in the EU, but we have country-specific law, particularly related to genetic data and health data. But the country-specific applicable law is, of course, a matter that engages lawyers and legal scholars worldwide. So it's not just an EU problem, but it's a problem, or a challenge, better to say, when we compare different countries around the world. I will be talking about some mechanisms to bring together regulations in this regard. As I have mentioned, GHGA's aim is to become the German EGA node, and this means a technical participation, of course. We need a technical interoperability, a technical binding into this European broader infrastructure, and of course, a certain kind of clinical data resources connection. But it also means, and I would like to emphasize this, a connection from the governance perspective, a connection and a communication between the different federated structure bits and pieces, which probably can also be identified as related to a certain legal regime or a set of rules that they underlie, and that might be different within this whole infrastructure. And that is also, among technical scientific issues, a reason for the federative approach. This is just an overview that you have a glance of how our work is put together in GHGA, and the issues that I'm dealing with are on the left side, attached to B1, the ethico-legal framework and patient participation. So it's ethics and the law. For ethics, it's my colleague, Professor Winkler, who is responsible, and I'm leading the legal framework, and we are strongly connected with the technical data, fair interoperability, and also the technical harmonization and standardization. And then, of course, to the whole structure of internal governance of our consortium. So that's it for an overview, which I was happy to provide in order that you can situate a bit the questions that I'm going to address now related to legal challenges within this work, because it particularly relates to it, but hopefully it will have an even broader impact. So yes, let's go for those legal challenges. I wanted to show you the slide to correspond to the one that I have shown about why is data sharing important in genomics, which most of you will know better than I. But why is this from a legal perspective interesting and important? I think that genomic medicine and genomic analysis changes many structures, many setups, many interactions to which law has until now reacted to with different regulations, particularly from the data processing and data protection law perspective, but also, of course, with other parts of legal regulation within medical law, etc. So there are many regimes that coordinate this kind of data processing. It's not just data protection law, even while we mainly focus on that. So if you think about how genomic analysis is done, it's quite important that when you once have the genome and analyze it, it really becomes a bit independent from time and this timely interaction with the patient, with the data subject, deriving results, because you can go back to your sequence data, the analyzers, get the data out, and do your research with it really independently from the participant, or if it's from a clinical context, from the patient. So there is this breaking up and in time in these relations that I think any kind of regulation or governance should be also reacting to. There is, of course, this space that changes, that you don't really need physically the participant or patient to be there with you. So it's really independent from this also interaction as between persons, physically present persons. There is quite a huge change in actors. It's not just in a secure medical context that you are having this bilateral doctor-patient relationship, but once you have collected this data, you might want to further use it for research purposes, you want to share it with other researchers. So there are a whole lot more interactions related to the data that is subject of the research, and many, many actors coming in with new roles, with new expert roles in this whole process, who needs to be situated somewhere also within the governance framework. And of course, there is this change in the connection between research and healthcare. I have mentioned now several times in the presentation the translational perspective, where it really a little bit merges in a sense that it's not like before, if I may put it bluntly, that you just, for an altruistic reason, provide your data for further research. Yes, that might be still the case, but probably with translational research, providing it for research, you as a patient or participant have good chances also to benefit from the results, and also the other way around. So there is this very strong connection, and I'm not quite sure we still can really very strongly and hardly divide all these research areas. So I think that this thinking about what kind of interactions, what kind of interests, what kind of legal positions play a role in this whole structure, need to think about all this change that is introduced through the ways we are dealing with genomic analysis and data combinations. And this is really just a very simplified way trying to introduce these changes. So in the remaining about 20 minutes, I will be focusing on 5 specific topics around dealing with this data. This is really selective, it's not comprehensive. Those are, I think, the main issues. They are related to hundreds and thousands of other smaller issues or bigger issues, etc. So please don't regard this as comprehensive, but I think it's a good road way down to emphasize the main challenges we are dealing with. One is the scope of application of data protection law, and with the mindset I just described about the changing interactions and roles and subject matters. Then the legal basis, as we say lawyers, is the justification for processing data in a legal sense, the data protection law roles, who does what and with what kind of responsibility. And then the last 2 points are data sharing on 2 different levels. One is the EU and the other are international data transfers going outside of the EU and the EEA. So let's go for the scope of application of data protection law. If we think about the scope of application, we need to realize that data protection law, the GDPR, concerns personal data. And if we look into the GDPR, how personal data is defined, it is really a very broad definition. So it's any information regarding an identified, so already identified, or an identifiable natural person, so someone who can be identified based on that data. So it's very broad, and of course there is a huge interest to know when can we talk about anonymized data, because if you have really anonymized data, you're out of the scope of this data protection law, which of course doesn't mean you're completely outside of the application of other legal regulations, but we are focusing on data protection law. Now, as it is common in law, there is no real standardized and from everyone commonly accepted definition of anonymization, but it is contested. And there are 2 main approaches. There is the absolute term. Anonymization is if you have no theoretical, no possible means to get back from the data to the person concerned. And the relative approach says that it really depends on how you process the data, where the data is, who has access to, for instance, if you have coded the data, to solving that code, etc. So it's really focusing on how the processing is done and whether in or under those circumstances, the data can be considered or qualified as anonymized or not. And I could now provide a long list of different opinions from European institutions or from the European Court of Justice, arguing with cases and papers in one direction or the other. Fact is that the GDPR has a little part, it's a bit hidden because it's in the recitals, which are not normatively directly binding, but can be drawn on to interpret the main body of the law, there is this hidden description of identifiability. What does that mean? And it means that data is then identifiable if you respect all the means that are reasonably likely to be used to get back to the person who is concerned by that data. And all these means considered that are reasonably likely to be used would allow to get back to that person. And this reasonable likeliness of usage has to be decided according to all objective factors, which means you need to respect what would be the costs of that process, how much time would it take, what is the available technology for that, and what kind of technological development can we expect. It doesn't matter who could really try this scenario. It could be the controller, the one who is actually responsible for data processing, or another person. But it should lead, as said, to an identification of the natural person, either directly or indirectly. Now, this is quite a broad definition, but if you really think about it, it narrows it down a bit, and it really communicates, I think, that anonymization is not a binary notion, so it's not black and white, but it's to be imagined, I think, on a continuum, and you really need to look into the possibility of this re-identification to decide whether you are dealing with anonymized data or not, which leads on a technical level in some countries, also in legal rules, to define a percentage of possibility under which you are then dealing with anonymized data. So I'm just saying a number. If you are, let's say, below 5% possibility to get back to the person concerned based on this data, considering all these means, then you're dealing with anonymized data. If you're above, you're dealing with non-anonymized data. So there are some legislations that draw a concrete line, but this is not the case, as you see with the GDPR. But the main message and take-home message is, I think, that the context really should matter whether you are dealing with anonymized data, which actually means then that there might be some context. So if I'm the controller, I have pseudonymized data, I have this whole pseudonymization key. Of course, the data in my hands will not be anonymized, but if I give it to someone else and they have no possible means or no reasonable likeliness, which would be the both options between absolute and relative approach, to get to these pseudonymization keys, or to reveal the identity of the person by drawing on other data, then in their hands the data could count as anonymized. So this is one first question we are dealing with, how to go about anonymization and when are we at all under data protection law or not. And this is particularly interesting from the genomic data perspective, because there are some genomic re-identification strategies, for instance, that you can determine people's names based solely on their DNA and trace amounts of associated metadata. There are publications or that you can retrieve personal data from aggregates of SNPs, the single nucleotide polymorphisms, across numerous individuals, and even when using only very few randomly selected gene loci. So there are some kind of investigations which show that genomic data is more appropriate and can be easily used to re-identify natural persons. So in most cases, you will be dealing with only pseudonymized data if you are handling genomic data. This might be the main consequence. However, this is also context specific and also contested then. But the main particularities is for research data infrastructure, for instance, how to deal with metadata. You would like to probably make your data searchable in order to adhere to the FAIR principles. So how will you provide that the aggregated information is definitely secure and does not count as identifiable data or personal data? The other question is how to go about relatives' interests. We all know that genetic data is not just individual, but it might become a family matter or a matter of relatives. And the question is, which is quite a huge discussion currently in legal literature, whether data subjects could refer to plural unnatural persons who are all affected through the same data. And of course, the purposes for what we use it might also be decisive. Inherently, you might have purposes where you will not want to completely anonymize the data because you want to benefit those persons concerned by the data through your analysis, translating research results back to stratified groups. So that was the first one, quite a big challenge, even at the very beginning. I will proceed to the second one in the interest of time, which is finding a good justification for processing data. Data protection law defines the obligation to justify the data processing, which means you need a legal basis, which is the legal term. And the most common legal basis will be consent, the informed consent of the patient. This has different reasons. Just to stick probably to the GDPR perspective, the role of consent in the GDPR is specific. It is the most strongly related to the informational self-determination of the person concerned and has a specific status with another legal basis, and it also is a regulation that does not need explicit member state implementation, but there is this provision in the GDPR and you can come and apply it directly. Member states can define different rules, but they must not. So this is an interesting description, probably why consent is so important. And of course, it's a relation to medical ethics and medical law, where consent has been very important to legitimize investigations and intrusions into patients and participant rights. If you think about retrospective data usage and you have old consent forms, to come to the practical side, it might be a question whether your old consent forms would still legitimize to use these data, to put them into data infrastructures, use that data for scientific research that you particularly could not foresee at the time when you have consented the patient or the participant. These are the questions around legacy consent, which we are dealing with in GHGA, and we are developing tools to decide what are the cornerstones to which the consent should adhere in order to make it appropriate to put data into nationwide infrastructure. But there is, of course, also the question how to define prospective consent formulations for the use of data and what kind of consent to use exactly. There are different specificities. If you are using sensitive data, health data, and genomic data, which count as special categories of personal data based on the GDPR, you need a specific consent. However, there is the rule in the GDPR that you might be able to use broad consent under certain circumstances, which means that you need to provide for enhanced security measures, for enhanced trust and confidence, and for enhanced transparency. But then you ask, okay, how to define this? And Datenschutz conference has described that dynamic consent might be a good way in providing this, but there are also other consent forms, tiered and layered. So these are the questions we are devoted to when we try to define how should consent look like retrospectively and prospectively to be able to process this data. There is a possibility, which does not really gain probably too much focus, to use other justifications to process the data. So according to the GDPR, even though we have this very important role of consent, there are still other justification possibilities to use the data for scientific research purposes. And this is actually the scientific research purposes themselves. So scientific research can serve as a motivation for a legal basis, for instance, because it's a public institution that is assigned with a task, such as universities, to promote and foster and conduct scientific research. And it can also be a legal ground, a specific exemption to be able to provide a special data category scientific research. However, probably that is why it's so unpopular. in order to apply this clause, we need to introduce a legal weighing related to defining the necessity and the proportionality of the measures of processing. So we need to look into necessity in the sense of, is it really the best way, the most effective way to reach my research purposes and least intrusive way for the data subject? And in order to define the questions of proportionality, we need to look into the importance of the scientific research to be conducted and the scope and extent and intensity of the inference that is then resulted through the scientific research for the data subject, and find a fair balance. Now, this is usually a question of law application, right? And it cannot really be standardized or only in a limited way because it's usually a single case decision making. And that, of course, somewhat hinders its standardized application. And what is also very relevant are technical and organizational measures and their understanding. They need to react to the result of this, thinking about the necessity and analysis of proportionality, because if we identify that it's unproportional, we need to provide safeguards. So actually, all these technical ways of how we allow data processing reacts to this kind of legal analysis and assessment, which I find quite important also from an interdisciplinary perspective. And there is the question of assigning data protection roles. I think you are acquainted all with the main roles one can have within data protection role. One can be a controller, responsible and deciding about what happens with the data. One can be instructed to do certain data processing steps, then one is only a processor. One could be jointly controller, responsible, or there is the possibility to even further instruct entities or actors as sub-processors to conduct certain steps. There is quite huge insecurity in different setups, how to delimitate these roles and their definition and who does actually what. It's quite important because the duties and responsibilities one has out of data protection law are attached to these roles. That's their main importance. And usually we say the one who decides what happens with the data and how it's going to be done is different. So the one who decides the main purposes and the essential means is going to be the controller, those who really just exercise and implement. The means are going to be the processor. However, it's not so easy to decide. And even if you are within one scientific consortium and you are jointly defining the aims of why we are doing this research, why we are needing the data, what is our setup, you might be defining different purposes related to the data, but they might be compliant and they might extend each other, which particularly strongly promotes the idea you are all joint controllers sitting in one boat of responsibility from data protection law perspective, which is not always something wished for through different entities, understandably. And then there is this perspective that those who are really controllers, mainly responsible, don't actually need direct access to the data. So if you don't even have direct access, you might be still the main entity or actor who bears the responsibility. And also, if you are jointly responsible with others, you must clarify your internal relationship, like who exactly does what, which might be also difficult, but you need to make this transparent towards the data subject. So that's also a question about delimiting and defining all those roles we are dealing with. We have the data sharing within the European Union, or we are approaching data sharing within the European Union with huge steps, let's put it that way. I mean, everyone thought and hoped that the GDPR is going to provide for harmonization in that regard. This is not the case for good reasons also, which has some, mainly constitutional law and competences issues in EU law I will not go into, but the main point is that the GDPR leaves room for member states to define their own rules through so-called opening clauses. And these could be different. And there is a particular specific rule defining that for genomic and health data, member states make their own regulations, making it even stricter than the standard of the GDPR. And so, yeah, different regulations in this regard might really, hinder joining data forces, so to say, within the EU, which is why there is this strong move in different infrastructures in the European health data space and 1 million genomes to federate infrastructures and data regimes, which is a good way forward. But then there is, of course, the question how these different data regimes and infrastructure bits and pieces will communicate with each other also on the governance perspective. Where again, then the different data protection rules and the question there too pops up, where we really need to think about, and this is also, for instance, an issue for us in GHGA, we need to think about that the decision-making related to data protection and data protection law relevant questions. As I mentioned, what happens with the data, what are the main purposes and the essential means of processing, are to be differentiated from scientific joint decision-making of putting infrastructures together, defining the infrastructures, not the data processing purpose, and so on. And I think it's not always clear that here is a very strong division. And if we look internationally, when it comes to collaborations. I think someone should be muted. Thank you. If you think about countries outside of the UEA internationally, it's sometimes a misunderstanding that by bundling the data protection responsibilities, the scientific decision-making responsibilities are also bundled, which is not the case. International data transfers, which is my last point, only shortly. It is a two-step process to decide whether you can transfer data outside of the EU. You need to adhere to the GDPR, to the whole rules about the legal basis, about risk assessment, about data security, but you also need an admissibility ground to be able to transfer data. And the cornerstone for this is adequacy, which means that the data protection level of the country or international organization where you transfer the data must be essentially equivalent to the level of protection provided by the GDPR. And in order to provide, again, for the communication between the different legal data protection regimes, the GDPR defines certain tools you can use. However, the problem is that it remains the role and the task of the data exporter to look mainly into the situation in the third country. There are some standardized tools by the European Commission, but they are really focused on only a few countries, such as adequacy decisions, and there are also standardized contractual clauses for data transfers. But actually their main, so to say, standard of when they can be used is also this adequacy of the third country's data protection level. And so there is this quite high burden recently on the data exporter to look into where am I sending actually this data, which makes it difficult to use these tools. And there are some possibilities for derogations, but they're also contested and probably not always appropriate, such as the explicit consent of the data subject, because the whole consequences out of the data processing you will not be able to really assess as a data subject. So we need to find workarounds and cycle spaces, and federation is definitely also one step forward and one way forward to provide for a better connection of different data spaces also internationally while adhering to data protection standards. And through the EGA connection and EGA Federation, we are also working on these issues. How can this look like? What does it mean for international data transfers and sharing? So time is up, and I wanted to show you just a very last slide in order to somewhat contextualize GHGA. And I think our main aim is, if I may summarize it way, is really to respect these changes I have elaborated on through genomics, and also to strive for a certain standardization in data sharing, which means that we would very much like to contribute to operationalization of law application, but also to develop tools for communication between legal regimes, territorially, but also sectorally, research and healthcare, and also to contribute to informing policymakers and stakeholders on our bottom-up experience, and through this possibly on the very long term to contribute to certain kind of harmonization with regard to genomic data sharing. I would like to very much thank you for all the people involved in GHGA. I mean, legal analysis is not sensible without scientific grounding for that and the purposes. And so you can see the board of directors listed and all the co-spokespersons who are involved and further participants. And I would like to thank my legal team who is seated at the Heidelberg Academy, and also for the collaboration with the ethics team. And I'm ready to answer any questions you might have. Just stop here. Thank you.
Thank you very much, Fruzsina, for the awesome overview and presentation. That was really some kind of blast.
Exhaustive.
And exhaustive, yeah. But so much information. That was really cool. Thank you. Today, I have the pleasure to be the moderator of the session. But before I switch into that role, I'd like to ask an icebreaker question. And this really came to my mind when I saw your presentation. And I never had thought too much about it, frankly spoken. Now, coming back to your first point in the very beginning, and that is that you have to consider how much effort and how much money someone puts into or may put into re-identification of a person in such a setting. And this seems to be like, you know, this is where things are being decided. That's my gut feeling. And it seems like a very tricky issue to judge that. And in particular, and this is my question now, what does the state of the art play as a role, or the so-called technical standard? Because means that are available right now might be outdated in a couple months or years, maybe, but maybe even days if the next breakthrough is coming around the corner. So how is this really related to the dynamics of technological means?
Yeah, that's a great question, and I think quite significant to at all be in a position to grasp how do I actually define these standards in order to be able to consider at all having anonymized data. And actually the technological development, put that way, bluntly, is also one crucial point that the GDPR, this register, lists. So you should be also considering technological development when you decide whether it's going to be identifiable or not. And now I cannot answer the question how you should do this, because obviously if you're a simple researcher, for instance, or even a research entity, let's go on the next level, you might not be able to foresee every kind of technological development, right, that is going to emerge. So it's quite difficult. And this is actually also a reason why those proponents for the absolute notion of anonymization, really say, okay, we cannot really regard this, so let's go for the stricter version. Yeah, that's all I can say to that.
Fair enough, I have to say.
Okay.
And I mean, it is also true that the means for predicting what technology is able to do these are in place, they are available. Of course, sometimes you can judge better than in other times, than in other cases, of course. And what I think was also a very, very relevant point was that you as a provider may go for a stricter option, which so it's really maybe a question of what is the value of the data and how likely is it that someone will spend any effort and will use any costs to re-identify individuals, which in some cases may actually be the case.
Yeah, exactly. I mean, there is this reasonability standard, which is, of course, I mean, this reasonable expectation is a legal term and has a legal meaning, but it is, somewhat overlapping in many cases with the common term of reasonable expectations. And we need to be clear about that as well,
I'd like to pick up the comments from the chat first. The first question is whether the slides are accessible or shared. That is probably an easy question to answer.
Yeah, not yet, but happy to share. So I think there was this recording, and I'm not quite sure whether there was the intention to upload them anywhere or something like that. So
maybe we just collect them and upload them and agree where to do that. Zenodo would be an obvious place. Then there's a question from Ulrich Sachs. Ulrich, do you want to raise your question by yourself?
Yeah, thank you very much again for your talk. It's great, touching all the relevant processes. My question would be, because we pondered a lot on it, do you have really a use case for Article 89 GDPR, this science exemption? My feeling is it's absolutely difficult. And in our recent projects, we used consent based on the UK data service 5 saves, telling that the data cannot be de-identified because otherwise it's useless for research, but we can make the environment safe, and we look at the people and the projects. That's would be very interested in your take on that.
Yeah, that's a good question. So Article 89, I think, has several points, and I'm not quite sure which one you relate to. So the general technical terms, specifically the data minimization, or the security measures generally to be able to at all process data?
Actually, it's more about consent. So because consent, you know, sometimes it's retrospectively it's impossible. So either you asked before or you didn't. So many cohort projects actually did not take into account the possibility to work on the data later. So I think that might be quite impossible. So prospectively, it's always better to inform and to, you know, the consent, the possibility of retraction. But sometimes the world is not so clean.
Yeah, so I think that there is other possibilities to use the data a justified way without consent. If you already have, for instance, data sets and you want to use them for a certain purpose, you were not able to inform the data subjects about at the time of collecting their consent and data. Which I don't think that, generally speaking, brings the data subject in a worse position than when you would go back to the data subject and collect a new specified consent. Because the GDPR's rules around data subject rights, which are actually providing the data subject a situation where he or she can control what happens with the data, like delete or erase or correct, etc., without relation to consent or your specific justification for the data processing. However, in order to exercise those rights, you will need somehow to give the information to the data subject. Otherwise, if they're not knowledgeable and not aware of what data and who and where and why is being processed, they of course are not able to somehow position themselves in relation to their data being processed. And I think the main question is how to fulfill those transparency obligations with or without consent. You can integrate them into consent, but the main question is, how do you really implement those obligations? For instance, is it enough to announce your research plan on the website of your institution, providing transparent information of what's happening with the data? How do you provide that the data subject will be able to connect, oh, this is the place where I gave my data or donated it, I don't know, 5 years ago. So all those bits and pieces of how do you really, apply transparencies, I think the main question, not really what is my specific justification to process that data, because transparency is a main principle in data protection law, independent from your concrete justification.
Okay, thanks. That's a long way to go. Data donation is a nice topic.
Oh yeah, I'm sorry, I didn't want to bring up another sensitive topic. Yeah,
also it touches this important aspect of consent management, which is largely unsolved for most cases.
Yeah, I mean, we're having the Data Governance Act in a draft version now from the EU, which is for all data spaces, and it should be detailed out for the different sectors. And the expectation is that there will be a specific detailing out for the European health data space. And in this general draft of the DGA, there is the consent management regulated, and there should be a European common consent form created for data management, and how this should look like. Yeah, I'm also really very curious to get to know.
Thank you. By the way, you may want to switch on your cameras while following the discussion. That is sometimes a bit nicer to see also some faces. And also the question is, does anyone have more questions? Please raise your questions, either by raising the Zoom hand or by raising a question in the chat. Since we are such a well-behaved audience, you may also start speaking.
I would also particularly like to invite anyone from GHGA who is here and would like to add anything specifically from the perspective of our consortium to do so. So, yeah.
Awesome. I think you have given such a good overview that for now we first have to process all the data and information that you gave us. And then maybe we and further people use the chance to ask questions also afterwards on the various occasions that we create during our NFDI exchanges. So thanks to Fruzsina for giving this nice presentation. Thanks for all the participants for joining our video talk. And thanks to the live watchers for following our stream. And thanks if you're watching this video afterwards for being interested in our content. Thanks to my team for organizing everything. And this gives me the final word. Please all stay safe and healthy, and see you next time.
Thank you very much.
Bye-bye. I think we should stay in touch with NFDI for Health, because we've got quite similar topics.